There is a specific kind of anxiety that comes when you stand at the base of something truly massive. I'm talking about looking up at a hydroelectric dam or a suspension bridge or, a nuclear power plant. Your brain just sees concrete and steel.
It is awe-inspiring, but when I look at those projects, I don't just see the physics, I see the paper.
The paper.
I see the web. The invisible and, frankly, terrifyingly complex web of legal obligations that holds it all together, because the reality is the only thing keeping that billion-dollar project from collapsing is a contract.
That's a haunting image. We think of engineers as the heroes, but it's the contract managers who are holding the chaos at bay.
Precisely. You don't build a mega project just with shovels. You build it with clauses. And if the rules of the game and that paperwork are weak, the project collapses long before you pour the first footing.
Which brings us to today's deep dive. We are stripping away the jargon to look at the operating system of the international construction world.
We're decoding the FIDIC Silver Book, specifically the 2017 edition.
The heavyweight champion of construction contracts.
Exactly. It's the standard for what are called EPC turnkey projects.
And I have to say, looking through the source material you sent over, specifically Clause 1, the general provisions, I am so relieved I don't have to sign one of these. It is intense.
It really is.
We aren't just reading terms and conditions here. We're looking at how risk is weaponized.
That is a great way to put it. These definitions in Clause 1, they aren't just a vocabulary list. They're the DNA of the project. They determine who bleeds money when things go wrong.
So let's set the stage. What exactly is this Silver Book, and who are these people at FIDIC writing all the rules?
So FIDIC is the International Federation of Consulting Engineers. The acronym, it actually comes from the French name. Clause 1.1.35 identifies them as the body publishing these forms.
Right.
They produce a whole rainbow of contract books, red, yellow, green. But the Silver Book is unique because it's for EPC turnkey projects.
Turnkey. I see that term in real estate sometimes. Turnkey apartment, just move in. Is that the same vibe here, just on a billion-dollar scale?
That is the philosophy. EPC stands for engineering, procurement, construction. So in this model, the contractor, who is defined in Clause 1.1.11, takes on almost the entire burden.
The whole thing.
The whole thing. They design the plan, they buy the materials, they build it. The employer, that's the client with the money, effectively waits to turn the key at the end.
That sounds fantastic for the employer.
It's convenient, sure, but it's expensive because when you hand over all that responsibility, you are also handing over a massive amount of risk.
And contractors don't take on risk for free.
Not at all. They price it in.
Right, and that pricing must depend heavily on when they make the deal. This brings us to a concept I saw called the base date in Clause 1.1.2. Why is that specific date so critical?
The base date is the line in the sand. It's defined as the date 28 days before the final deadline for submitting the tender.
It's a freeze frame.
Exactly. Think of it as a snapshot in time. When a contractor gives you a fixed price, say $500 million, they're basing that price on the information and the costs available at that specific moment.
As of today, this is what the world looks like, and this is my price.
Perfect. So if the price of copper triples the day after the base date, that's now a change in circumstances. The base date is the reference point.
This leads to the inevitable argument, right? You should have known that was going to happen.
And that is where the Silver Book gets incredibly sharp. We need to look at Clause 1.1.77, the definition of unforeseeable.
I looked at this. In normal English, unforeseeable means, we couldn't have guessed it.
A meteor hitting the site.
Right, or a zombie apocalypse.
In FIDIC land, it is much, much stricter. The contract defines unforeseeable as not reasonably foreseeable by an experienced contractor by the base date.
That phrase, experienced contractor, seems like a trap.
It's an objective standard, not a subjective one. It doesn't matter if you, the specific person bidding on the job, didn't foresee it. The legal test is, would a veteran top-tier contractor have foreseen it?
So it creates this hypothetical supercontractor to measure you against.
Exactly. If an experienced contractor would have checked the data and spotted the risk and you didn't, that is not unforeseeable. That is your negligence. You pay for it.
That puts immense pressure on the bidder. Now, speaking of being precise, I want to talk about the language itself. Because Clause 1.2, interpretation, has a grammar lesson that I think is worth millions.
The power of shall versus may.
It sounds so trivial, shall and may. But in a dispute, these words are everything, aren't they?
They're the difference between a choice and a command. Clause 1.2, letters E and F make it absolute. Shall means an obligation. You must do it.
No wiggle room.
None. May means you have a choice. You have the option. If the contract said you shall inspect and you didn't, you're in breach. Game over.
There's also a small note in Clause 1.2 about gender. It says words indicating one gender include all genders.
It's standard modernization. If it says he, it implies he, she, or they. It prevents anyone from trying to find a loophole based on pronouns.
People will try anything when millions are on the line. Let's talk about that money. I noticed the Silver Book distinguishes between cost and profit. Why the split?
This is crucial for claims. Let's say the project is delayed, the contractor loses money, they file a claim. Clause 1.1.16 defines cost as all expenditure reasonably incurred, but it explicitly excludes profit.
So if I claim cost, I'm just breaking even.
You're just getting your wallet replenished. You aren't making a dime on top.
But there's another term, cost plus profit, in Clause 1.1.67.
Right. That's the golden ticket. That is cost plus a percentage markup. But here's the catch. That percentage is supposed to be stated in the contract data.
And if they forget to write a number in?
Did you catch the default?
I did. It says, if not stated, 5%.
5%. Now think about the construction industry. Your corporate overheads, your risk margins, they might be way higher than that.
Oh, 5% is razor thin.
Exactly. So if you're hoping for a 15% margin on a huge change order and you forgot to specify it, you are legally stuck with that default 5%.
That is a painful lesson. It seems like the theme here is check the contract data.
Always. The book is just the template. The contract data is where the actual deal lives.
That actually leads perfectly into our next bit. Because on a project this big, you have mountains of documents. What happens when one document says, build the wall 10 feet high, and another says 12 feet?
This is the hierarchy of documents in Clause 1.5, and it's strictly ranked. Think of it like a royal court.
Okay, who's the king?
The king is the contract agreement, the actual document signed by both parties at the end. It overrides everything else.
And beneath the king?
You have the particular conditions. This is split into Part A, that contract data we just talked about, and Part B, the special provisions. These are the custom rules for this project.
So this specific deal you negotiated beats the standard template.
Correct. And they override the general conditions, which is the standard Silver Book text we're analyzing now.
Now, what about communication? If I want to tell you something, I send a text. But Clause 1.3 seems to suggest that kind of casualness is a death sentence here.
It absolutely is. It deals with notices. And this is where more claims are lost than anywhere else. A notice is not just a communication, it's a formal legal flag.
So I can't just email the project manager and say, hey, heads up, the concrete is late.
You can, but that is not a notice. To be valid, it has to be in writing, and this is the kicker, it must be identified as a notice.
You have to literally write notice on it.
Yes. Usually notice of delay or notice of claim in the subject line. If you don't, the employer can say, we never received a formal notice, and you lose your right to the money.
It's like magic words. If you don't say the spell correctly, nothing happens.
It is bureaucratic, but it's designed to force clarity. Also, look at the systems. Electronic notices are allowed, but only if they come from the systems stated in the contract data.
So if the contract says we use Aconex for notices and I send it via Gmail,
It might be invalid. You missed the hoop.
there's another acronym here, NOD.
Notice of dissatisfaction. That's your weapon when you disagree with a ruling from the employer's representative or the dispute board.
The I object of the construction site.
Precisely. If you don't send the NOD, you've legally accepted their decision. It keeps the fight alive.
Let's shift gears to intellectual property. We're building a high-tech power plant. Who owns all that design work?
This is a huge misconception. Employers often think, I paid $1 billion for this, I own everything. But under Clause 1.9, the contractor retains the copyright.
Wait, so the employer pays for the design but doesn't own it?
They own the physical plant, but they don't own the idea. Instead, the contractor grants them a license.
A license, like software.
Similar idea. Clause 1.9 says the license is non-terminable, transferable, and royalty-free, but it's limited in scope. It lets the employer operate, maintain, alter, repair, or demolish that building.
But not build a new one.
Exactly. The employer cannot take those blueprints and use them to build a second identical plant in the next town without the contractor's consent.
Ah, I see. You bought the car, but you didn't buy the factory specs.
Exactly. It protects the contractor's know-how.
What about red tape? Permits, zoning. Clause 1.12, compliance with laws. Who's standing in line at the city planning office?
It's a split responsibility. Clause 1.12a says the employer is usually responsible for the big picture permits, planning, zoning, the right to build something on that land.
Okay, so the employer gets the right to exist.
Right. But 1.12b says the contractor has to get everything else required for the execution. Road closures, crane permits, labor visas, tax clearances.
And if one of them drops the ball,
the indemnity clause kicks in. If the contractor forgets a permit and the project gets shut down, the contractor pays for the losses, and vice versa.
Now, I want to get to the heavy hitters, risk and liability. I want to talk about joint and several liability in Clause 1.13. This is for joint ventures, right?
Yes. Clause 1.1.4a defines a joint venture, or JV. Mega projects are often too big for one company, so they team up.
But Clause 1.14 makes it sound like a marriage with no prenup.
It's worse. Joint and several liability means the employer sees the JV as one single entity. If Company A goes bankrupt, the employer doesn't just lose half the project. They can come after Company B for the entire obligation.
So Company B is on the hook for Company A's incompetence.
Fully. You are liable for your partner's mistakes, their debts, their failures.
Oh.
And the leader of the JV can bind everyone. So if the leader signs a bad deal, all partners are stuck with it.
That changes how you look at a partnership. You're underwriting each other's survival.
Trust is very expensive in this business.
Okay, the nightmare scenario. The plant is 3 years late. The losses could be astronomical. Can the employer sue the contractor for infinity dollars?
Generally, no. This is the shield. Clause 1.16, limitation of liability. It sets a cap on how much pain the contractor can take.
How does that cap work?
Well, first, it filters out indirect losses. The clause says neither party is liable for loss of profit, loss of any contract, or indirect or consequential loss.
Whoa, hang on. If the power plant is 6 months late, I'm losing 6 months of electricity sales. That's loss of profit. You're saying I can't sue for that?
Not as loss of profit, no. That's usually considered a consequential loss, and it's excluded. The risk would be uninsurable otherwise.
So the employer just eats that loss?
Not entirely. They can usually claim delay damages, which is a pre-agreed penalty per day, but the actual commercial loss, that's typically off the table.
That seems like a huge win for the contractor.
Yeah?
And there's a total cap, too.
Yes. Clause 1.14 says total liability usually won't exceed the sum in the contract data, or if it's left blank, the contract price.
So it's a $100 million contract. The most you can lose is $100 million.
Ideally, yes. It creates a worst-case scenario you can plan for, but. And you knew there was a but coming.
There's always a but.
There are exceptions where that shield just dissolves. The cap does not apply in cases of fraud, gross negligence, deliberate default, or, and this is the scary one, reckless misconduct.
Reckless misconduct? That sounds aggressive. How is that different from just being bad at your job?
Negligence is making a mistake. You calculated the load wrong. Reckless misconduct is seeing a red flashing light warning you of danger and smashing it with a hammer so you can keep working.
It's a total disregard for the consequences.
Exactly. And if a court decides you are reckless, the liability cap vanishes. The exclusion of lost profits vanishes. The employer can sue you for everything you have.
That's the difference between having a bad year and going out of business.
It keeps people honest, or at least it keeps them cautious.
We've covered a lot of ground. Definitions that trap you, notices that need magic words, liability that spreads like a virus. It's heavy stuff.
It is. But I think the takeaway for you listening is that the FIDIC Silver Book isn't really about engineering. It's a risk allocation machine. It balances the employer against the contractor.
And it highlights that in high-stakes business, ambiguity is the enemy. Written means written. Base date sets the timeline. Notices must be labeled. It's about being clear.
Absolutely. And even if you aren't building a dam, these concepts apply to almost any serious business deal.
Before we wrap up, I want to leave everyone with a thought about that unforeseeable clause we touched on at the start. Clause 1.1.77. Not reasonably foreseeable by an experienced contractor.
The standard that keeps contractors up at night.
It really is. And I wonder, in the world we live in now, with climate change, with pandemics, with shifting geopolitics, can an experienced contractor reasonably foresee anything anymore?
It's a dangerous question. As our data modeling gets better, the excuse of we couldn't have known gets weaker and weaker. The definition of unforeseeable might be becoming a trap.
Something to mull over. Are you agreeing to predict the future? That's it for this deep dive into the FIPC Silver Book. Thanks for listening.
Stay safe out there.
If you're interested in the templates, please visit our shop. The link is in the description.
Thanks for watching. Please subscribe and see next time.